Good afternoon. This hearing is called to order. 50 years ago, the United States and the Soviet Union were locked in a period of intense international crisis. 2 decades of the Cold War had resulted in the Berlin blockade, the Soviet Union's testing of the atomic bomb, the successful launch of Sputnik, the Cuban Missile Crisis, and the Vietnam War. However, despite the prolonged period of intense international crisis, a remarkable event occurred. The United States and the Soviet Union were able to come together and author the Outer Space Treaty, which was intended to become a foundation for all future activity in outer space. The main tenets of the treaty include the prohibition of the placement of nuclear weapons and other weapons of mass destruction in space or on a celestial body, the requirement that states are responsible for national space activities, whether carried out by governmental or non-governmental entities, and states that outer space, including the moon and other celestial bodies, are not subject to national appropriation by claim of sovereignty. Following ratification by the Senate, the United States, the United Kingdom, and the Soviet Union were among 60 nations to sign the Outer Space Treaty, with signing ceremonies in Washington, D.C., London, and Moscow on January 27, 1967. President Lyndon B. Johnson hailed the signing of the treaty as, quote, an inspiring moment in the history of this human race. However, in the half-century that has since passed, many articles of the treaty haven't been fully tested, as the majority of activities in space have primarily been carried out by governmental entities. But that could soon change, as the United States is poised to lead an explosion in commercial space activity that will see American companies look to land on the surface of the moon, service satellites, and mine asteroids which may contain platinum and other precious metals valued upwards of trillions of dollars. While the future appears bright, we cannot afford to become complacent. The United States does not stand alone in this new emerging space race. Just last month, it was announced that China and the European Space Agency are interested in creating an outpost on the moon. As activities in space increase, they will undoubtedly pose new challenges as countries and companies compete for resources throughout the universe. We should anticipate that there will be conflicts as countries and private industry race to reach areas of the moon that hold significant advantages, such as the, quote, peaks of eternal light and the lunar sites that may hold vast quantities of water. These sites will provide economic and operational advantages for those who reach them first. Therefore, it's incumbent on Congress to use this 50-year anniversary of the Outer Space Treaty to properly determine our actual international obligations, to decide if specific articles in the treaty are self-executing or not, and to ensure that our domestic policy moving forward creates an environment that provides certainty for industry while protecting our national security. Those decisions will be made by this committee, by the Senate as a whole, and by the Congress and the President. And this committee, this is the second in a series of hearings looking at reopening the American frontier in space. That's why we're gathered here today. The testimony that this committee will hear will help pave the way to the future of space exploration and our global competitiveness. Every little boy and every little girl knows the experience of looking up into the night sky, looking to the stars and wondering what's out there. That's the mystery, that's the wonder that is behind this collective endeavor in which we're engaged. If this committee can working together in a bipartisan manner, as it has succeeded to doing for several Congresses now, if we can come together behind a strong national space policy that ensures continued American leadership in space, then I have no doubt that in the not-too-distant future, those same little boys and little girls will be looking up at the moon, looking up at Mars, and looking up at Americans walking on the surface of those bodies, perhaps living on the surface of those bodies, exploring new opportunities that the mind can scarcely imagine. That's what this hearing is all about. With that, Senator Markey.
Thank you, Mr. Chairman, very much, and thank our witnesses. This is a very, very forward-looking hearing, and because we're going to be looking at how our policy can support a growing commercial space industry. We are here today to explore how the Outer Space Treaty impacts commerce, impacts settlement in space, and impacts what may be needed to provide a regulatory framework that grants certainty to businesses and investors and establishes an international understanding of expectations for countries and companies operating in space. The Outer Space Treaty provides a set of principles for space activities that guides all countries and is an important foundation to build upon to ensure America's interests are preserved in outer space. There are things that were not anticipated or planned for in this treaty when it was negotiated in the late 1960s. The testimony today will explore some of those issues and how U.S. policy might help address some of those concerns. In particular, Article 6 of the treaty, which gives governments the responsibility for all space activities from their nation, whether undertaken by the government or not, has been an issue. I look forward to hearing the views of our witnesses on what is needed to create effective and efficient policies that will promote the reasonable, rational, safe, and fair use of space. Space policies need to include room for all nations' responsible activities, for small businesses as well as large, and for science and nonprofit activities as well as for profit activities in this new frontier. The United States continues to be a pioneer in space activities, and our policies should support the continued innovation that has been the key to America's economic success. I look forward to working with this subcommittee and stakeholders to ensure that America continues to be a leader in space. I look forward to working with you, Mr. Chairman, and leaders like Senator Peters and Senator Hassan to accomplish that goal.
Thank you, Senator Markey. At the outset, without objection, I want to enter into the hearing record a letter from the Secure World Foundation, a letter from the Michael J. Listner of Space Law and Policy Solutions, and a letter from the Heinlein Prize Trust. We will now turn to the first of two panels that this committee will hear. The first panel, we have three witnesses. I want to thank each of you for being here today. Our first witness is Mr. James Dunstan, who is a senior adjunct fellow at Tech Freedom and the founder of Mobius Legal Group. Mr. Dunstan has spent more than 33 years counseling private businesses on all aspects of doing business in outer space and has assisted federal and state governments with space law issues. Our second witness is Ms. Laura Montgomery, who is the proprietor of Ground-Based Space Matters law offices and publishes groundbasedspacematters.com. Ms. Montgomery works on issues of regulatory space law with an emphasis on commercial space transportation, human space flight, and the outer space treaties. Ms. Montgomery has spent over 2 decades with the Federal Aviation Administration's Office of the Chief Counsel, where she represented the FAA at the United Nations Legal Subcommittee of the Committee on Peaceful Uses of Outer Space. And our third witness is Mr. Matthew Schaefer, who is the Veronica A. Haggart and Charles R. Work Professor of International Trade Law and co-director of the Space, Cyber, and Telecommunications Law Program at the University of Nebraska College of Law. Mr. Schaefer has taught international law, international business, and foreign relations-related courses since 1995 and has directed the Space and Cyber Law Program since its creation in 2006. Mr. Schaefer is also co-chair of the American branch of the International Law Association's Space Law Committee, and I would like to note that Mr. Schaefer previously served as the director in the International Economic Affairs Office of the National Security Council at the White House in 1999. And before we hear from the witnesses and their testimony, I want to welcome and recognize the ranking member of the full committee, Senator Nelson, who has a long and enduring issue in the topic of space.
Well, I am very, very pleased that we have made the progress that we've made. The commercial space sector has been truly outstanding in the accomplishments, and that's exactly what was intended as we started some 7 years ago, this dual track where we had a commercial space program that was going on with regard to astronauts, a commercial space program going to and from the International Space Station, and simultaneously, we have the NASA program to go out and explore the cosmos. And of course, people don't realize it. It's right here. Within the next year and a half, both commercial rockets with crew will launch, as will the largest rocket ever, the SLS, with its spacecraft Orion on top. So indeed, Mr. Chairman, what's going to happen is the American people are going to really get engaged again. I want to add a word of caution, however, because the budget that was just submitted by the President just today, it would cut $500 million from NASA. There are some positive elements, like full funding for the commercial crew, and some not so positive elements, such as the cuts to earth science, to education, and to exploration. But the spending plan simply does not go far enough for NASA or for various space centers, including our space center, the Kennedy Center in Florida. As we have all said in the past, we're going to work together on both sides of the aisle, and NASA is not partisan. NASA is nonpartisan. We're going to work together to make sure the agency gets what it needs so that we can keep building this momentum. And, Mr. Chairman, we're going to Mars.
Amen and hallelujah. With that, Mr. Dunstan, you may start us off.
Chairman Cruz, ranking members Markey and Nelson, and members of the subcommittee, thank you for the opportunity to testify here today. I am truly an orphan of Apollo. As children, my generation watched the Apollo astronauts walk on the moon. We were promised that if we studied hard and ate our vegetables, we too could go into space. Unfortunately, that didn't happen. I was in law school when the space shuttle started to fly. Again, we were promised flights every 2 weeks, and that we'd be able to fly experiments for as little as $10,000. None of that happened either. At its peak, the shuttle flew only 9 times in 1985, and any hope of conducting affordable commercial activities aboard shuttle died with the Challenger. But space commerce has taken off anyway on private vehicles. The industry now nears $350 billion annually in revenue, mostly in commercial satellite services. And we're seeing the dawn of a radical new generation of launch vehicles with flyback first boosters and flyback second stages just over the horizon. Launch costs may fall by an order of magnitude. Startups have raised real financing to do everything from on-orbit servicing to asteroid mining. For these companies, once esoteric provisions of the Outer Space Treaty could create real business risks. It's time for Congress finally to address the relationship between government and private sector under Article 6 of the Outer Space Treaty, something I assumed we would have tackled imminently when I graduated from law school almost 35 years ago. Article 6 makes each country responsible and liable for the activities of its citizens and companies in space. The treaty also leaves up to each country to decide how to authorize and supervise private activities. In other words, Article 6 is not self-executing in governing private citizens. Just consider the Supreme Court case in Medellin versus Texas, which Chairman Cruz argued as the Solicitor General for Texas. Quoting Federalist Number 33, the court said that whether a treaty is self-executing means, quote, comparing laws that individuals are bound to observe as the supreme law of the land versus a mere treaty dependent on the good faith of the parties. Article 6 falls into this latter category. Thus, even failing to adopt any regulation at all would not violate the Outer Space Treaty because there is the backstop of the national liability for private citizen activities. Federal law already authorizes Americans to operate in outer space. Americans have inalienable rights to life, liberty, and pursuit of happiness, as the Declaration of Independence puts it. The 10th Amendment made this principle binding constitutional law. The powers not delegated to the United States by Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. In short, absent a constitutionally consistent law prohibiting innovative space activities, Americans are already authorized to pursue those activities. In other words, that which is not forbidden is permitted. And we do have laws and regulations, plenty of them, that govern the activities of private citizens in space. Space entrepreneurs need permission from multiple government agencies. This includes the FAA, AST for launch, FCC, NOAA, NASA, and the DoD. Entities conducting launches have to answer to both state and local authorities, everything from assessing environmental impact of launches to obtaining permits to transport their vehicles across state and county lines. The problem isn't a regulatory vacuum, but a patchwork of cumbersome, burdensome, and sometimes inconsistent regulations. Congress should clean up this mess at the same time that it addresses how to govern innovative space uses not clearly governed by existing rules. Precisely because the United States Constitution promises me that I can go to outer space, and precisely because Article 6 is not self-executing, Congress is in a unique position internationally to show the world that we recognize our liability under Article 6 and our obligations to ensure that our private citizens abide by the self-executing provisions of the OST, no nuclear weapons in space, no military bases on the moon or celestial bodies, and no appropriation of a celestial body. The United States can thus lead internationally by adopting a sensible and non-burdensome regulatory regime to ensure treaty compliance. This would put the rest of the world on notice that countries that would offer flags of convenience for outer space activities cannot dodge their liability obligations. This would also promote the goal of Article 1, the peaceful exploration and use of outer space, while protecting U.S. assets, both public and private, from irresponsible foreign companies. There is also nothing to be gained right now from reopening the current treaty regime. Once the United States demonstrates a light touch regime consistent with treaty requirements can work, then reopening the treaties might make sense. But doing so now would allow countries that aren't friendly to the United States or American capitalism to layer on costly regulatory burdens that the United States would have to reject, as we rejected similar provisions of the Moon Treaty. My written testimony, co-authored by Baron Zelka, President of Tech Freedom, explores in greater depth the United States' responsibilities under Article 6. Thank you again for the opportunity to testify, and I look forward to answering your questions.
Thank you, Mr. Dunstan. Ms. Montgomery.
Thank you. Chairman Cruz, Ranking Member Markey, and members of the subcommittee. Thank you for inviting me to address the role the Outer Space Treaty may play in the regulatory responsibilities of the United States. This country has the opportunity to interpret the treaty in two ways, as conducive to private activity or so that it creates barriers. A close reading of the text shows that the treaty actually allows a lighter regulatory hand than many claim, both in terms of the authorization and supervision provisions of Article 6 and the harmful contamination provisions of Article 9. If the United States pursues an interpretation that closely aligns with the text, there may be no need to seek changes. I respectfully recommend that the United States understand that it need not regulate new commercial space activities such as lunar habitats, mining, or lunar beer brewing for the wrong reason, namely the belief that Article 6 makes the United States regulate either any particular activity or all activities of United States citizens in outer space. A misunderstanding of the treaty looms as possible regulatory drag because many, including agencies in the executive branch, claim Article 6 prohibits operations in outer space unless the government authorizes and supervises those activities. The U.S. government should not interpret this as forbidding unauthorized private space activity for three reasons. First, the treaty does not forbid private operators from operating in outer space. Second, it does not say that either all or any particular activity must be authorized, leaving decisions regarding what activities require regulation to the member states. If Article 6 truly meant that all activities had to be overseen, where would oversight stop? Life is full of activities, from brushing one's teeth to playing a musical instrument, which take place now with neither federal authorization nor federal supervision. Just because those activities take place in outer space does not have to mean that they should suddenly require oversight. And finally, Article 6 is not, under U.S. law, self-executing, which means that it does not create an obligation or a prohibition on the private sector unless and until Congress says it does. So concerns over regulatory risk are artificial and may be set aside. Because Article 6 is not self-executing, it is not enforceable federal law until Congress acts. Just as the Supreme Court said in Medellin versus Texas, when the court did not let the president enforce a ruling of the International Court of Justice against the states because Congress had yet to act, Article 6's call for oversight requires legislation with all its attendant policy choices. Accordingly, regulatory agencies should not attempt to enforce this treaty provision by either denying licenses or payload authorizations or by attempting to regulate that which they have no jurisdiction over. Nor should Congress pass a law so broadly worded as to encompass all activities that could take place in outer space. The Supreme Court, in criminal and First Amendment cases, says laws should be drafted so that persons of ordinary intelligence can tell what is forbidden and what is required, and that would be a good model to follow here if Congress takes that path. Article 9 of the treaty offers another source of concern, but it doesn't have to. Article 9 provides that states parties to the treaty shall avoid harmful contamination of outer space and adverse changes in the environment of Earth. This provision does not, in other words, apply to private actors. The United States is thus not legally obligated to impose this requirement on the private sector. Even if Congress were to decide that private activity had progressed to the point where harmful contamination had become a concern, Congress would have policy decisions to make, including whether current government guidelines should stand in the way of human settlement in outer space and on the moon and other planets. Because the harmful contamination provision is neither applicable nor self-executing, regulatory agencies should not attempt to enforce it until and unless Congress directs them to do so. In order to put to bed the regulatory uncertainty arising out of any misunderstandings of the treaty, Congress could take a number of approaches. The most certain and long-lasting, however, and the one that would reduce the opportunities for confusion, misunderstanding, and regulatory overreach, would be for Congress to prohibit any regulatory agency from denying a U.S. entity the ability to operate on the basis of inapplicable or non-self-executing provisions of the Outer Space Treaty, including Articles 6 and 9. Thank you for the opportunity to testify today.
Thank you, Ms. Montgomery. Mr. Schaefer.
Chairman Cruz, Ranking Member Markey, members of the subcommittee, honor and pleasure to be here today for this very timely hearing with the Outer Space Treaty's 50th anniversary, all the innovative and important new space activities, many representatives actually in the audience today, and given the fact the U.S. has a current authorization gap for new space activities, things like asteroid mining, lunar landers, on-orbit satellite servicing, lunar research facilities and laboratories. This gap creates a problem in two ways. First, it creates uncertainty for industry. That doesn't help investment. That doesn't help business cases. Second, as activities go forward, it may create compliance problems with our international obligations, which also creates problems, as I'll elaborate on a bit further here. The U.S. has agreed to a set of treaty interpretation rules internationally that are expressed in the Vienna Convention on Law of Treaties. The primary rule in that document is that we interpret treaties according to the ordinary meaning of the terms of the treaty in their context and in light of object and purpose. It's very clear that Article 6 of the OST calls on the U.S. and other parties to the OST to authorize and supervise commercial space activities in order to assure their compliance with the OST. It further makes parties internationally responsible for non-governmental activities in outer space. And this seems to set fear into people, and it shouldn't. OST obligations are very minimally burdensome and quite flexible in how they can be interpreted. It's a basic set of principles of minimally burdensome rules, which, by the way, help advantage U.S. companies as well. If we don't respect our obligations under Article 6 of the OST to create an authorization and supervision regime, we're going to face consequences. Our industry will face consequences. Foreign retaliation. A lot of businesses are global in nature. They depend on global partners, customers, and investors to make out their business case. When the U.S. doesn't respect its international treaty obligations, foreign governments can retaliate, take away markets, take away customers, and foreign investors can shy away. Foreign partners can be taken away. Secondly, when the U.S. is first movers up in outer space, other countries will not respect these basic minimal norms when it comes to how they will interact with that first moving U.S. company. Both of those things create uncertainty for our companies. On the self-executing nature of the treaty, we could debate that endlessly. The U.S. Senate has done an excellent job since the Medellin case, making very clear which articles of treaties are self-executing and non-self-executing since that 2008 Supreme Court case. For older treaties, we're trying to glean from treaty text and less explicit materials. But the important point is, even if the OST Article 6 is non-self-executing, the international obligation remains. If we do not comply with it, we will face the consequences I just laid out. Further, the Congress has directed, when it comes to launch licenses and payload reviews, has directed the Department of Transportation to take into account our international obligations. What is creating the gap is not a failure of Congress to direct the administration to comply with our international obligations. What creates the regulatory gap is the legislative history to the 1998 amendments to the Commercial Space Launch Act that indicate that Congress was not intending to grant on-orbit authority. The U.S. Congress did an excellent job in the Space Resource Exploration and Utilization Act, once again mentioning our international obligations when they laid out that there can be property rights in extracted resources, a long-standing U.S. interpretation of the treaty. That continued continuity internationally created certainty internationally and also helped the U.S. lessen vocal opposition to the law. That's the play out of the playbook that should be adopted when we establish an on-orbit authorization regime. In short, there's no need to terminate the OST. There's no need to amend it. There's no reason to stray from our agreed-upon treaty interpretation rules. There's no reason to ignore the plain meaning of Article 6. And there's certainly not a need to pay attention to certain OST obligations and reject others. We can have an OST-compliant regime that meets the spirit of permissionless innovation, something that led to the growth and success of the Internet economy. And I'd be happy to share further ideas with that in the question and answer session. Thank you very much.
Thank you, Mr. Schaefer. Thank you to each of the witnesses. There are a number of important issues that have been raised by this testimony. I want to start with the question of Article 6 and the extent to which Article 6 and the OST is self-executing. And for those following this hearing who are not necessarily living in the minutiae of treaty law, the notion of self-executing is a fairly straightforward notion. It is a question of whether treaty language is in and of itself binding domestic law that has force of law on private citizens within the United States, that is enforceable judicially, and that binds the government. If a treaty is not self-executing, Mr. Schaefer is right, that doesn't mean the treaty has no force. It means its force is diplomatic and political in nature, that there is an international obligation, but it is not binding and enforceable law in United States courts. If I understand the testimony of the panel correctly, the first two witnesses, Mr. Dunstan and Ms. Montgomery, both testified that Article 6 of the treaty is not self-executing in your judgment. And Mr. Schaefer, if I heard you correctly, you were a bit more agnostic on whether it was self-executing or not, although at a minimum you didn't testify affirmatively that it was self-executing. Is that a fair assessment of the testimony?
we can take as a given it's non-self-executing. Again, I think people can come to different conclusions. It's one of the reasons why the Medellin case itself was a 6-3 opinion of the Supreme Court, right? But set that aside. Let's even accept the view that it is non-self-executing. All it means is the executive branch doesn't have current domestic authority to look at OST obligations for new on-orbit activities. But again, the international obligation remains. If the U.S. doesn't do that, we will suffer international consequences. And the administration almost implicitly admitted it's non-self-executing because they asked the Congress to enact legislation. And I should just say, even if it's self-executing, it still wouldn't matter. There'd be a great need for the Congress to act on an authorization regime anyway, because we don't want to just look at OST compliance, these minimally burdensome rules of the OST. We want to look and see whether an applicant is interfering with an existing U.S. licensee's activities. We would want to look and see whether an applicant is interfering with an existing U.S. government, particularly a critical national security asset. So there's a number of factors Congress would want to have an executive branch agency look at anyway. And so there's that need to act separate and aside from this question of self-execution or non-self-execution.
Well, and I would note, going even a little bit further than you did, that I think the executive certainly has the authority to recognize international law obligations and to make discretionary decisions consistent with those obligations, even if a particular treaty is not self-executing. It's what the executive cannot do is violate United States law. Medellin versus Texas, which each of the witnesses has discussed, is a case I know very well because I argued and won the case on behalf of the state of Texas, and so spent many, many hundreds of hours deeply immersed in Medellin versus Texas. It is interesting in the discussion here in that each of the witnesses also, if I understood you correctly, none of you are advocating reopening the Outer Space Treaty for renegotiation, and all three of you are arguing that consistent with the treaty language, it is possible to have a light touch regulatory regime, or I think, Mr. Schaefer, you used the permissionless regulatory regime. Is that accurate? And if so, should Congress legislate a framework for commercial activity in space and incentivizing enhanced commercial activity in space, and what should that framework look like if we were to legislate in that direction?
Well, I'll kick off, Mr. Chairman. I think the important thing to understand about Article 6 is there are two notions that are contained in Article 6. The first of which is that nations are responsible and liable for the activities. So really how the United States chooses to authorize and supervise is a matter of risk assessment for the United States government. How much risk are we willing as a government to allow, and therefore how much of a regulatory regime do we want to pile on? And so it is this sort of risk versus reward, and I can tell you, from my experience in private practice, if the regulations become so burdensome, all of this stuff can easily go offshore. We saw that with our satellite construction industry after the implementation of ITAR, and we could easily see it on this. I've already had clients who have looked at the existing regulatory regime, how expensive it is to get a FCC license, for example, and they've gone overseas to do this. And so we must be cognizant of the fact that if we don't get it right, we're going to have flight of this technology in this industry abroad.
I think one of the important things to consider in contemplating a regulatory regime is to make sure that it is actually very narrowly tailored to only those things which are hazardous to others or could create interference, so that we would avoid the pitfall proposed by the Section 108 report that came out of the previous administration, where everything would require authorization and supervision. I think we should start by federalizing Connecticut if we want to take that route and see how it works out. It's a small state, and we could see if this is actually a feasible project. But that being said, I don't think that the treaty does require any particular activity to be addressed or authorized even. And I think that mining is a perfect example of that. On the ground, mining is dangerous. There's landslides, toxic fumes, horrible issues for worker safety, cave-ins, environmental issues. In outer space, there's no one else around. And if your robot is mining an asteroid where no one's going to get hurt, what is the purpose of government regulation? And if you don't need the regulation, why do you need the authorization? I use the frivolous example of playing the harp on the moon as something that clearly doesn't require governmental oversight. And that goes to the point that you need to draw lines as to what requires oversight and what does not. And so clearly, lunar beer brewing might be dangerous. Pressure vessels, I don't know, gases, but it might not. And so before we start saying everything needs to be regulated or that Article 6 requires the regulation of everything, Congress needs to go through its usual process of saying, is this something that is so hazardous or could cause such interference to others that it needs to be regulated? And if it does, it should call out, as we have in the past, launch needs regulation, reentry needs regulation, satellite interference needs regulation, but we shouldn't say everything. That's...
So permissionless innovation is never or rarely pure in the sense of no regulation at all. But at its core, there's a default presumption in favor of approval. And the Congress could certainly include a default presumption in favor of approval of these new space activities in an OST-compliant regime. They can certainly limit the number of factors the executive branch can take into account, the OST compliance, the not interfering with existing U.S. commercial space activities, not interfering with important U.S. government existing activities and assets, and also by giving agency that has promotion authority and experience with licensing and running an interagency process for space the lead over that process. I'll also say, because it was brought up, planetary protection standards. There's been some talk that COSPARS, that was created in a science era of space, somehow now is what meets the definition of harmful contamination. And the State Department explicitly has rejected this view. So COSPARS is not setting any minimum floor that commercial actors need to comply with. And the Congress can actually have significant deference given to industry created standards for those terms that have significant flexibility in their interpretation, like harmful contamination and like harmful interference. Last thing I'll say is Ms. Montgomery mentioned it's sort of like trying to federalize everything in Connecticut. It's really not. The better analogy is, because space is a non-sovereignty zone, it's really like telling U.S. citizens that travel to Antarctica, another non-sovereignty zone, here's a few minimal criteria you have to follow to ensure we're complying with our international obligations and that you're not interfering with existing U.S. activities or U.S. government activities down there. That's the appropriate analogy for what we're trying to do here.
Thank you, Mr. Schaefer, and I'll note the next senator up, the ranking member, is the senator from Massachusetts. He might well be in favor of federalizing Connecticut.
I know there are some red states that believe they've already been federalized, and that was the subject.
Indeed.
That was the subject of the 2016 campaign. Give me your view as to what the reaction would be in Russia, or China, or India if the Senate legislated in the area of Article 6, if it put requirements on the books. What's the reaction internationally if we do that, Mr. Schaefer?
So I think if we do that, listen, there's going to be some countries that oppose our interpretations of various OST provisions for matters of national interest regardless. But I think when we comply with Article 6 of the OST, we increase the number of countries that we have credibility to lead towards the U.S.-inspired to the commercially friendly inspired interpretations of the treaty. And when we don't comply with Article 6 of the OST, what we do is we send some countries, China and Russia's way, although China actually has been noticeably pretty quiet when it comes to asteroid mining and property rights. But as a general matter, we send countries their way. And we also have less credibility to insist those countries, when, again, a U.S. company is a first mover, if we don't have as part of our criteria for authorizing commercial companies, looking at whether we're doing harmful interference with a pre-existing activity of them, we won't have the credibility to insist on them doing the same for us.
And that's always the issue for the first mover. There are fast followers, sometimes even faster followers. So you have to think through the consequences of that. Mr. Dunstan, what do you think?
I think, again, as I testified, that the United States is in a unique position because of our constitutional historical background, because of the sort of notion that Americans are free to do what they want unless they are prohibited from doing it. By taking action here, the Congress, I think, can lead internationally, as we have in other areas, as Congress did just a couple of years ago with the CSLCA and extracted resources. We led. Sure, there was a pushback from some in the international community claiming that that was equal to an Article II appropriation violation, but yet many other countries are following suit. See what Luxembourg is doing. We certainly have led in suborbital tourist. The approach that the United States has taken and directed the FAA in terms of that has been followed suit by other countries. We are, by being the first mover, we can be the leader, and I think that what Congress does here is going to be extremely important going forward, and I think ultimately will be followed by the vast majority of other countries.
Okay, Mr. Schaefer, I heard you say in your testimony that you felt that there were lessons from the internet that could be applied in outer space. Can you give me some details in that analogy that could help us to flesh out how we might proceed from here?
Sure. Permissionless innovation is a concept. You don't want to stifle innovators, people that are dealing with sophisticated technology with overly burdensome regulation. Actually, a lot of the space entrepreneurs, internet entrepreneurs, they're not real keen on hiring lawyers as their first people on board. They bring them on kind of last and reluctantly, right? And that's great. We want the engineers let free, right? But with that said, again, permissionless innovation is rarely, if ever, pure, and it's contextual. The space context is a little bit different because we do have an international agreement we're party to, the OST, that has an Article 6 that says we have to authorize and supervise, and the ordinary meaning of the term authorize is give official permission to. And the important point, though, is this is not going to lead, or certainly doesn't have to lead, to overly burdensome regulation or an overly burdensome checklist that the executive branch would run through. But that is one contextual difference between the internet, which we have very little international law and treaties on, unless you're talking about use of force issues, then you can get into some treaties, but very little treaties on that. In outer space, that's one difference. The other difference is in outer space, it's long time horizons for investment typically, and there's some new business models that shorten that time horizon and whatnot. But in the internet, it's very, very quick, right? But when you have a long time horizon for investment, you really do need certainty. And what happens when you have this authorization gap, you're creating domestic uncertainty. Hey, who do I go to get authorization? Do I really need it? Are my investors still going to come on board? And then the international uncertainty of not complying with Article 6. Are foreign countries going to cut off access to foreign customers, to foreign partners, and whatnot? When you're dealing with long time horizons, it's really important to have that certainty and predictability for sure.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Thank you to our panelists for your testimony here today. One issue that came up in another committee, I serve on the Armed Services Committee and dealing with space policy. One issue that came up of particular concern is the amount of space debris that now exists in orbit. I think I was reminded of a recent launch by India where there were 104 satellites, I believe, on one launch vehicle. That many of those are U.S. nanosatellites, but nevertheless, an awful lot of stuff is going up there into the tens of thousands to keep track of. And as you are well aware of, this material is moving at 17,000 plus miles an hour and can cause a great deal of damage. Give me a sense of what you think, or should we put together some sort of legal framework to deal with this debris differently than we do now? Whoever.
There are existing regimes on the commercial side, regulatory regimes that address debris. The FCC and NOAA both have debris rules and require mitigation of the creation of debris. The FAA also has regulations that require, that you power down your batteries and vent your upper stage so that there is no debris created. The question is whether other things will require debris regulation, such as satellite servicing, perhaps. Those all have cameras and transmitters on them, and they could all perhaps be placed without any change in law under the existing regimes of the FCC and NOAA. So I think there's something in place now. Whether more is
Is
required,
it sufficient in your mind?
it sort of covers everything you can think of at the moment. So I do think it's sufficient for the moment.
Does everybody agree?
Well, I'd chime in. There are actually potentially 5 different government agencies that have their own separate, and they sit in 5 different sets of the Code of Federal Regulations. They're all based on models and standards adopted by NASA years ago, but they're all slightly different. And so it's actually possible to have a mission where you may have to have 3 or as many as 4 different orbital debris mitigation statements. And if one of the agencies disagrees or wants a change, then you have to loop all the way back through. And so this is when I talked about sort of the cumbersome regulations, because they all sort of grew up generically with each of these stovepipes. A sort of consolidation of that authority, I think, would really be helpful to industry. And I would agree there is enough on the books right now, as long as we enforce it and make sure that they abide by the debris mitigation standards, that's really not a worry going forward.
So there's if I understand both of you correctly, there's enough out there already, but we need to harmonize, in your estimation.
Yes, harmonization would be very nice.
Schaefer.
The one thing I would add, there's a certain element of the scientific community that would like to see actually active debris remediation. So mitigation is actually, the mitigation guidelines internationally that are inspired actually by the U.S. originally have certainly helped. But when you have incidents like the Iridium incident in 2009 or the Chinese ASAT test in 2007, those types of activities can basically erase a decade's worth of beneficial mitigation activities. So there is some thought for sustainability of space, you would want to actually remove some of the existing debris, and the problem becomes, people would say the thing to remove is the largest mass objects, and a lot of them are actually of Russian origin. And that gets us into ownership of space objects. So there are some legal hurdles to doing that. But in addition to the mitigation guidelines that are there internationally, enforced by the U.S. Through licensing criteria that Ms. Montgomery spoke of, that's another thing. In fact, I believe Congress in an enactment called on the administration to start looking more into active debris remediation in a 2010 or 2012 statute.
Well, and finally, you mentioned, of course, the Russian debris and other debris from other countries that are now engaged in active space programs. You've talked about the regulatory framework we have here in the United States. What's your assessment of the framework broadly with other countries that are launching spacecraft into orbit in relation to debris?
I would say generally most countries are compliant unless it's in their interest not to be. There was a ESA satellite not that long ago which had been launched a number of years ago, and they ultimately ran it dry. It's the size, almost half the size of this room. It's one of the largest satellites ever. And rather than deorbit it, which they should have, which the debris mitigation standards required, they just ran the thing dry. And their argument was, one, it was still producing scientifically important information, and 2, it was designed prior to when ESA had adopted. And so they went so far as to not say it wasn't launched, it was designed, and therefore, so there are many instances when countries in their own self-interest will either waive, and we do it ourselves from time to time. There are a number of Iridium satellites that have been, that the FCC has waived the requirement that they be deorbited because they want to run them dry of fuel. And so I think we have to be honest with ourselves and say we have these mitigation requirements and we need to stick to them, even if it might not be in our own interest to do so.
All right, thank you.
Senator Nelson.
I would ask, how is the existing outer space treaty regime beneficial to the U.S. space industry? And I would leave hanging for Colonel Melroy in the second panel, what are the benefits of the existing outer space treaty regime for our commercial, civil, and national security space interest?
One area of in the area of liability, it does create a certain amount of certainty because the treaty set out how a particular country is a launching state and therefore liable for any damage caused by activities that launch from the country, that the government of that country launches or procures, or using the facilities of that country. So a lot of that certainty is very useful for the commercial sector. It's been implemented domestically for the launch industry through the Commercial Space Launch Act, and that has proved to be a benefit for the commercial industry.
I would add that one of the most important provisions of the Outer Space Treaty is the provision that states that any object that is launched from the surface of the Earth is the property of the launching state and always will be the property of the launching state. And so that makes very clear from an international basis that nobody can come along and pluck off your satellite under international law. Now, the flip side, as Mr. Schaefer pointed, when we've got all this junk, all this abandoned stuff up there, it still remains the property of say, Russia, all these upper stages. And unfortunately, we don't have sort of concepts of maritime law where we could go in and just yank these things out. But it certainly gives confidence to an American company that if they launch a satellite, it will always remain theirs, and they can operate it so long as they abide by United States law.
So I think it's a great question. You know, we talked about minimally burdensome things in the OST on U.S. companies, but the reciprocal side, the other side is they do benefit U.S. companies. Article 2's non-appropriation, non-sovereignty obligation. If some other country is a first mover, you know, there's going to be a couple countries that are possible first movers. If some other country is a first mover, we're not going to have an entire U.S. industry blocked from that area of a celestial body because there's free access to all areas of celestial bodies. So those things are certainly in our business's interest. The fact that countries have to think about whether they're causing potentially harmful interference with U.S. activities before they proceed. So there are protections in there that do provide more certainty for U.S. companies in terms of their business plans and ventures.
Thank you. Senator Hassan.
Well, thank you, Mr. Chair, and thank you to the panelists. We're obviously talking about the opportunities that space exploration presents for scientific discovery and advancing our knowledge here on Earth and creating new opportunities for our businesses to thrive. And I'm really pleased that you're all here today and that the committee has gathered to examine the U.S. Space Treaty and whether and how this legal framework can be improved upon or sustained. As Senator Cruz indicated, I also wanted to make sure that the testimony from Michael Lissner was in the record. Mr. Lissner happens to be not only a space expert and founder of the legal and policy consulting firm called Space Law and Policy Solutions. He's based in my home state of New Hampshire. I have spent a little time looking at his testimony, and I think it reflects what we've been discussing, which is the fact that the decision about whether to withdraw from the Outer Space Treaty would be a very difficult one for us to make. There are obviously lots of considerations, most of which that I had on my mind you've all touched on, but I wanted to give you the opportunity just to help us think through, as we all assess these matters, how we should balance the interests of industry stakeholders for further exploration and advancement with our top priorities in national security. What should we be thinking about in terms of that balance?
That, of course, is the difficult question, is how do you balance, and I would say there are three balancing acts. There's the commercial aspect, there's the scientific aspect, and then there's the national security aspect. And it's a tough balance to do. I can just report, in terms of my experience in what could potentially become a parallel mechanism, which was the ITAR, the International Trafficking in Arms Regulations. And what we saw there was a regime which was non-transparent, which was non-appealable. It was essentially a black box. And so whatever we do, that balancing, to the extent we can, we understand there are national security interests where we can't always give you a reason no, but we've got to have a regime that allows you to have a right of appeal, has the right to get an answer, as opposed to with the ITAR regime, it was just no, and you never found out why no. And so transparency in whatever Congress does, I think, is critical, and that will give, I think, the industry as much sort of certitude as it can get.
Thank you. Ms. Montgomery.
Yes, I think one of the problems, I agree with everything Mr. Dunstan said, just to start with, but also one of the solutions to that, as Congress considers drafting legislation, is to not use very vague language. There's lots of statutes in the space arena out there that just talk about national security. Well, there's lots and lots of things that could mean, and unfortunately, it can sometimes mean that the regulatory person in charge of figuring out if there's a national security issue sits there somewhat paralyzed. What could I be missing? And then you get lots and lots of delay. So I think that if Congress clearly articulated the standards, for instance, we do not want anyone and I'm just making this up, we do not want anyone transmitting pictures of my secret satellite back to Earth, and just make that a clear prohibition, then that would be very helpful. And so, of course, the National Security Agency might give you a little bit more vague than what I just said,
Right.
but perhaps not so vague that the non-transparent black box becomes the norm.
Thank you. Mr. Schaefer.
I would just say there are some competing interests there, but sometimes not. There are some synergies too. And in fact, one of the things I recommended in my written testimony was Congress actually declare that these new space activities, at least the ones that are foreseeable, are actually in the national security interest of the U.S. to have U.S. companies be the leaders. To take a couple examples, China controls 85% of the rare earth minerals or more in the on Earth. If we have U.S. companies, and again, it depends whether there's an ultimate business case for it, but if we have U.S. companies that are able to get access to those minerals on celestial bodies, that can change the dynamics. It's also in the U.S. interest for U.S. companies to be the first to do and the best at satellite servicing. It requires rendezvous and proximity operations, better to have that technology or the most advanced technology in the U.S. and having U.S. firms do that. So I think the interesting thing is, I know in remote sensing it seems like the trade-offs are a little more stark, but in these new activities there's actually a lot of synergies, and I think Congress could actually so state in the law to limit that national security barrier to some of the commercial activities.
Well, thank you, and thank you all for very thoughtful testimony.
Thank you. Let me ask another question that came up in some of the answers here. There was multiple references to satellites and space junk and property rights. And I want to ask the panel's view on what should the legal regime be. Mr. Dunstan referenced maritime law, for example, encouraging salvage. Should we have a similar regime encouraging salvage and the removal of space junk? And a related question, Article 2 of the Outer Space Treaty says that outer space, including the moon and other celestial bodies, is not subject to national appropriations by claims of sovereignty, by means of use or occupation, or by any other means. Is that prohibition consistent with our interest in encouraging robust investment in exploration and development of outer space? We have the last great frontier in America settling the West. We had the Homestead Act, which provided an acute financial incentive for people to take the great risk of going and investing. Do we need, with respect to outer space, with respect to the moon or Mars, the equivalent of 40 acres and a mule, 40 miles in a lunar rover, is what role should property rights play in space, either with satellites or with lunar settlements or settlements on Mars or otherwise? And I would open this to all the witnesses.
I think that there's 2 points on the property rights question, and I'll leave salvage to someone else. But the Article 2 does not prohibit commercial or private ownership of land, and I think that's very clear. The fact of the matter is that property rights serve as a great incentive to investment. If you don't have property rights, you cannot put up your land as collateral. You cannot get investors. There's nothing to securitize your investors' interests. And you yourself are hampered in your ability to plan if you don't know that the property that you are using and hopefully going to be spending decades on is yours. So I do think that the United States should figure out a way to recognize property rights extraterrestrially, and I do think that the Outer Space Treaty allows that. I do believe there are a lot of people who disagree with my view, and I think that it is something that needs to be looked at very carefully and thought through, because the incentives are there for development if there are property rights. Thank you.
So I would disagree with Laura, the first time I've disagreed with her today, because I don't think the Outer Space Treaty as it is written would allow for the United States to even recognize domestically that. But I would give you another analogy to the opening of the West, and that would be the fact that the United States retained title in what are now the reservations of the Native Americans. And yet you are able to go on and buy a mining lease or a drilling lease on those. Now, it's cumbersome, but that's because we put this bureaucracy on top of it. But people can go in and mine resources off of our Native American reservations and extract those resources and profit from them without actually owning the land on which they're doing that. And so I think in that way, an asteroid could be the same thing. You can't own the whole asteroid, but everything you take out of it becomes yours. And that's what Congress recognized with the CSLCA in 2015.
So let me press you a little bit on that, Mr. Dunstan. 2 follow-ups. One, your initial testimony, you did not advise renegotiating the OST. I want to ask how that's consistent with the answer you gave. And 2, the analogy of Indian territories, there the United States, if you're retaining title under Article 2, the United States and other nations can't make claims of sovereignty. So how is that, how do we reconcile that to incentivize serious investment?
So the Native American analogy is the fact that the United States owns the land, not the tribe. And so put the United States in this analogy at the sort of international level. Okay, and so the tribe doesn't own it, yet the tribe can enter into mining leases, which don't would then convey a property right underneath it. So I use that analogy to say that you don't have to have underlying property rights to still do extracted resources from it. And secondly, I think Article 2 is pretty clear that we can't domestically recognize property rights. We would have to go in and renegotiate that treaty, and I think that's a...
But from whom would you obtain the lease? In your analogy, you have the United States from whom you could obtain the lease. The international community, there is no entity from whom to obtain a lease.
That's correct. You just can go out and mine that asteroid. You just can't own that asteroid. You can't obtain a property right in the whole asteroid, only with what you extract from it.
And you'd say same for the moon and for Mars?
Same for the moon and Mars, yes.
Mr. Schaefer?
Well, on the question of salvage, maritime salvage doesn't work for most space debris because most space debris is valueless, so there's nothing to be saved from the peril, so to speak. There is a little used concept called liability salvage that's got some reflection in U.S. maritime law where you're saving the person from the liability they would face if their piece of junk hits something. But given the fact that it's a fault-based standard in space, who's at fault if a piece of debris hits an active satellite, the thing that can move or the thing that can't move? And it might depend a little bit on the facts. Was the debris created in opposition to the internationally recognized debris mitigation guidelines or not, so it'd be very fact-specific. But liability salvage may have some application there, but pure maritime salvage doesn't work. On the property rights issue, I think, at least in the short to medium term, obviously, U.S. interpretation of OST, and as recognized by the Congress, you have property rights in the extracted resources. That's 35 years at least of U.S. interpretation now confirmed and codified by the Congress. In terms of cordoning off areas, it's really the non-interference right that comes into play there. And it might be better to proceed on a case-by-case basis with that, because we could get U.S. company versus U.S. company, both going for same areas of a celestial body, and what is a non-interference right encompass. We could have U.S. company versus foreign country in that situation, and it's probably best to leave the discretion in the executive branch hands case by case with those guiding principles than try and do a complete rewrite and upset of Article 2 of the OST, which I think very few countries would join. I think bilateralism, case by case, is probably the better way to go.
Well, thank you to each of the witnesses. I think this was a very productive and educational panel. I will note that I'm looking forward to trying Ms. Montgomery's Celestial Moon Beer, if and when it is brewed. And with that, I want to thank each of the three witnesses in the first panel and welcome to come forward the second panel, which we will move immediately to as soon as you have a seat. I want to welcome the second panel now. We will have a total of 4 witnesses. The first is Dr. Bob Richards, who is a space entrepreneur and a futurist. He is co-founder of Moon Express, Inc., a space transportation and lunar resources company located at Cape Canaveral, where he currently serves as president and CEO. Dr. Richards chairs the Space Commerce Committee of the Commercial Spaceflight Federation, serves on the board of the Space Foundation, and is a member of the International Institute of Space Law. Our second witness is Mr. Peter Marquez, who is the Vice President for Global Engagement at Planetary Resources, where he is responsible for working with governments around the world. Mr. Marquez has held positions in the Air Force and the Office of the Secretary of Defense, working on national security space programs and special programs. After his time in the Pentagon, Mr. Marquez served on the National Security Council as the Director for Space Policy for President George W. Bush and also for President Barack Obama. Mr. Mike Gold is the Vice President of Washington Operations and Business Development at Space System Loral. Mr. Gold previously served for 13 years with Bigelow Aerospace, where he supported a variety of non-traditional space activities. Mr. Gold also serves as the chair of ComStack, which is the federal advisory committee that provides advice and counsel to the Federal Aviation Administration's Office of Commercial Space Transportation. And finally, Colonel Pamela Melroy is a retired Air Force test pilot and NASA astronaut. Colonel Melroy is a veteran of 3 missions to the International Space Station and is one of 2 women to command the Space Shuttle. After leaving NASA, Colonel Melroy worked in industry and at the Federal Aviation Administration's Office of Commercial Space Transportation. Colonel Melroy recently left DARPA after serving 4 years as the Deputy Director of the Tactical Technology Office. Colonel Melroy is now owner and CEO of Melroy and Hollett Technology Partners. Welcome to each of you. Dr. Richards, you may begin.
Thank you, Mr. Chairman, Ranking Member Markey. It's an honor to be invited to speak with you today about reopening the American frontier and unleashing the innovative power of the U.S. commercial space industry as a driver of the nation's space economy and settlement. Our need to expand humanity into space is not in question. To consider otherwise would put a expiry date on the human species. What is in question is the way that we will expand into space, and which nations will set the standards of freedom and endeavor and reward as we enter these new frontiers. As a country built on the foundations of Earth's frontiers, the United States stands unique in all the world with the opportunity to focus the power of its entrepreneurial history and enterprising vision to open up the space frontier, and in so doing, create a peaceful, prosperous, and boundless future for all humanity. Today, I address you as the founder and CEO of Moon Express, a privately funded commercial space company created to seek and unlock the resources of the moon through a progressive series of commercial robotic missions, starting with our maiden voyage scheduled to launch late this year. Relevant to the subject of this hearing is that last year, after months of interagency consultations, Moon Express became the first commercial entity to receive formal U.S. government approval to send a robotic spacecraft beyond traditional Earth orbit and to the moon. This was, in fact, the first time in history that any government aid signatory to the Outer Space Treaty exercised its rights and obligations to formally authorize and supervise a commercial entity to fly beyond traditional Earth orbit and to the moon. The framework we used for our mission approval was an interim patch that built on the existing payload review process of the Federal Aviation Administration Office of Commercial Space Transportation, with a series of additional voluntary disclosures intended to help satisfy U.S. obligations under the OST. We worked independently with all stakeholder federal agencies who in turn worked collaboratively and creatively to find a way to approve our ad hoc approach, even as Congress and the administration determine a more formal framework. Looking beyond our mission approval, which is an interim solution, we support a process that focuses on streamlines the regulatory framework, limits the government's role to a light touch, promotes American innovation and investment, and satisfies our international obligations. In essence, we believe that a commercial space activity should enjoy deemed authorization, presumed authorization, unless there is a clearly evident or meaningful demonstrable impact on national security, U.S. obligations under international treaties, or harmful interference with others. The key to our survival as a species, in fact, the only key we hold in the long term, is to evolve into a multi-world species, harnessing the practically infinite energy and resources of space and easing the pressure on our home planet. Preservation of the Earth and our civilization is precisely the reason we need to expand our economic and societal sphere into space, beginning with the moon and then beyond. But it's not just about boldly going. It's about boldly staying. It's about moving the economic sphere of Earth outward in a way that uses the material wealth of space to solve the urgent problems we now face on Earth, to bring the poverty-stricken segments of the world up to a decent standard of living without recourse to war or punitive action against those already in material comfort, to provide for a maturing civilization the basic energy vital to its survival through freedom of commerce in space. We are at the cusp of a magnificent adventure, an evolution of our species perhaps as significant as the evolution of life from ocean onto land. Our emergence from Earth into the ocean of space holds promise and opportunity, but also dangers of migrating conflict. And for the first time in human history, an opportunity to conquer new worlds without conquering each other. The United States has taken proactive measures to support its private sector and has interpreted the Outer Space Treaty in a favorable ways to the Constitution and the founding principles of this country. While the Outer Space Treaty may appear antiquated, and in some ways it is a remarkably visionary document with profound principles that have served the world well for decades. I believe time and energy is better spent in continuing to interpret the Outer Space Treaty in favor of international collaboration without constraining the rights, the benefits, of the freedoms of U.S. commercial enterprise. We aspire to the stars. Mars beckons as a second home for humanity. The moon is our gateway. Thank you, Mr. Chairman, for the opportunity, and I welcome questions afterwards.
Thank you, Dr. Richards, and I appreciated your invocation of the mission statement to boldly go where no one has gone before, or perhaps the most famous split infinitive in all of history. Mr. Marquez.
Chairman Cruz, Ranking Member Markey, thank you very much for the opportunity to come here today and talk about the Outer Space Treaty. I especially want to thank you and your staff also for the 2015 passage of the CSLCA. It was a tremendous event for this community, so thank you. I come here today representing a multinational asteroid mining company, Planetary Resources. We exist to extract and utilize resources from asteroids that are needed for humanity to create a truly universal space economy, have a permanent presence in the solar system, and increase the quality of life for all people living on Earth. We'll harvest water from asteroids to be used as fuel for spacecraft and satellites, as life support for a space workforce, as radiation shielding, and to grow food. We'll extract metal, which will in turn be 3D printed, so that we can construct nearly anything in space and any component needed. And we'll provide the fuel and raw materials needed for any long-term, sustainable, and scalable mission to the Moon, Mars, and beyond. And in the long term, we will bring back extremely scarce resources like platinum group metals to the Earth to increase the quality of life for everybody. We'll continue to build upon the great successes that we've had so far. In 2015, our company began the asteroid mining age when we launched our first technology demonstration satellite. In 2016, we used materials from a meteorite to 3D print the first object 3D printed from outer space material. We've built 2 follow-on satellites that will be launched soon. And in 2020, we will launch and operate the first ever private deep space mission. We will also conduct an unprecedented mission to visit, survey, and prospect several near-Earth asteroids. Our team that we have is an example of, I think, many of the commercial space companies here now. Our engineers have helped design, build, and operate a variety of Mars missions to include all the recent landers and rovers. We have a staff that comes from a variety of industries, from mining to semiconductors to planetary science to agriculture to the automotive industry to the IT community and many more. And despite what Mr. Schaefer said, we do have a pretty good law and policy team on staff too, coming from the State Department, the UN, the White House, and the national security community. For Planetary Resources to accomplish this mission, we need stability and predictability. This nation has a history of not only supporting commercial space activities, but leading and implementing the international legal structure that created that stable and predictable space environment. During the early negotiations of what would become the Outer Space Treaty, the U.S. actually fought to include commercial space activities because they believed it would be important. On the other side of the argument was the Soviet Union, which sought to have those operations limited to governments only. If the U.S. had not promoted those principles early on, I would not be here. My fellow panelists would not be here. There'd be no Blue Origin. There'd be no Virgin Galactic, no X Prize, and none of the other hundreds of small businesses that support this community across the country. This U.S. national space policy was founded on these principles. Indeed, the principles from President Eisenhower on have become the foundation of our international legal environment and the Outer Space Treaty. Principles that we as a nation have held since the dawn of the space age enable the very space commercial capabilities that we have now. The treaty has proven to be a flexible foundation for those activities. Indeed, one of the keys to the treaty's enduring relevance is that the framers did not attempt to regulate specific activities. To do so, or today for that matter, would be a recipe for obsolescence. Instead, the treaty establishes foundational principles. There are now active discussions in the international community about how to interpret and apply the OST, these unprecedented activities. The U.S. comes to these negotiations from a position of strength. For one, the U.S. played a leading role in the treaty's formation, as I said, and it is this unbroken consistency of the U.S.'s interpretation of the treaty and application of the treaty for more than 50 years and across the past 12 presidential administrations that is key to our credibility in this process. For our company, the value of the international legal framework is clear. Without it, we'd be trying to operate in a reality without rules, chaos and anarchy. However, the treaty must be meaningful and responsive. And in order to do that, we will need the appropriately interpreted and implemented national legislation. As I mentioned before, the CSLCA is an excellent example of how to build upon the foundation of the Outer Space Treaty with national law. None of this is to say the treaty is perfect, or that it's complete, or that Congress's work is complete. We are concerned, however, that opening up the treaty will leave our industry worse off and will overall be to the detriment of national and international security. And as a brief aside, I would say that it's worth noting that many of the principles and motivations espoused in the early U.S. negotiations and garnering the support of the Outer Space Treaty were to protect national and international security. And given my previous occupations, I'd be remiss in not mentioning the purpose of many of these things. My strong recommendation is that we continue to build upon the Outer Space Treaty with strong national legislation. And with strong national legislation and international collaboration, our commercial space industry will continue to thrive and innovate to broaden our horizons, add to our knowledge, and to improve our way of living on Earth. Thank you, Mr. Chairman.
Thank you, Mr. Marquez. Mr. Gold.
Thank you, Chairman Cruz, Ranking Member Markey, dedicated subcommittee staff, for this opportunity to discuss the Outer Space Treaty's impact on American commerce and settlement in space. I serve as Vice President of Washington Operations and Business Development for Space Systems L'Oreal, or SSL. SSL is America's most prolific commercial satellite manufacturer. Over 80 satellites built by SSL are currently in orbit and providing coverage to the entire populated surface of the Earth. SSL is also a global leader in space-based robotics, advanced propulsion, as well as data extraction and analytics. There's never been a more exciting time to be in the space industry. Asteroid mining, space tourism, private sector space stations, and commercial lunar rovers are all transitioning from science fiction to reality. We are living in an age of wonders, and like every other space activity, satellite operations may be transformed by new ideas and technologies. For example, the operational lifetime of satellites is nearly always limited by their fuel supply. This can and will change. Via the Restore-L program, SSL and NASA are developing robotic LEO spacecraft that will rendezvous with and refuel satellites. If the Restore-L mission is successful, it could fundamentally alter the nature of satellite operations while providing the U.S. with a vital technological advantage. Moreover, SSL was selected by DARPA to support the robotic servicing of geosynchronous satellites, or RSGS program. RSGS, an innovative public-private partnership between DARPA and SSL, will produce a robotic servicing vehicle that can repair satellites in orbit, as well as replace or add new components to a satellite. Per DARPA's participation in RSGS, satellite servicing will not only bolster job creation and enhance American competitiveness, but such capabilities will be critical for national security. In testimony to the Senate Select Committee on Intelligence earlier this month, Dan Coates, the Director of National Intelligence, stressed that China and Russia are developing directed energy weapons, missiles, and robotic spacecraft capable of disabling American satellites in both LEO and GEO. Restore-L, RSGS, and satellite servicing in general will substantially bolster the security and resiliency of America's vital orbital assets while supporting domestic high-tech job creation and commercial innovation. However, satellite servicing and all other forms of new space activities need funding. And what investors are looking for is a legal regime that offers certainty, transparency, and efficiency. Article 6 of the Outer Space Treaty requires nations to provide authorization and continuing supervision of their private sector space activities. This treaty obligation actually aligns with the desire of investors for regulatory certainty. Investors and insurers need to know that relevant federal departments and agencies, particularly the Department of Defense, the Department of State, and NASA, will not object to their proposed activities. Unfortunately, there is no established process for the federal government to provide entrepreneurs with this regulatory reassurance. Currently, companies, including SSL, are bringing their innovative space activities to the FAA Office of Commercial Space Transportation, or FAAST. The FAAST conducts an interagency review and subsequently has provided companies with what is called a payload approval letter. The simplest, least bureaucratic, and most expeditious means of addressing not only Article 6, but providing entrepreneurs with the predictability that they desire is for Congress to direct the FAAST to establish an enhanced payload review process that would leverage and formalize the work that the AST is already successfully conducting. Additionally, when such payload review approvals are issued, they should contain a proviso requiring that if substantive changes occur, the private sector applicant will update the FAAST. This simple proviso, in conjunction with the enhanced payload review process, would be sufficient to meet Article 6's authorization and continuing supervision requirement. Even with any Article 6 concerns fully resolved, the Outer Space Treaty still contains a variety of clauses and provisions that are vague or challenging for private sector operations, such as Articles 2 and Articles 12. Despite these challenges, it would still be ill-advised for the U.S. to withdraw from the treaty or open it up to revisions. Although the treaty is imperfect due to its focus on principles instead of prescriptive requirements, it has largely stood the test of time. The treaty has provided a foundation that international space law and public and private sector activities depend upon.
If the U.S. pulled out of the treaty, it would create confusion and uncertainty, hindering new commercial developments as well as established private sector space activities. Moreover, opening up the treaty to amendments would risk the international community inserting even more language that would run counter to U.S. interests. Instead, the Department of State, in cooperation with the private sector, should engage with like-minded countries, particularly launching states, to establish bilateral and multilateral understandings regarding aspects of the treaty that require additional clarity and interpretation. Again, predictability, efficiency, and transparency are the key values necessary for a successful legal regime. If Congress can do its part and provide entrepreneurs with the regulatory certainty that they need, we can all start spending less time with lawyers and more time on launches. Thank you for this opportunity.
Thank you, Mr. Gold. Colonel Melroy.
Thank you, Chairman Cruz, Ranking Member Markey, and your superb staff for inviting me here today. It's a privilege to be here to discuss this important topic. Today, I'd like to talk about satellite servicing. Satellite servicing is not new. As a NASA astronaut, I had the privilege of conducting and overseeing robotic activity on the space shuttle and during the construction of the International Space Station. To date, only the Space Shuttle, ISS, and the Hubble Space Telescope were designed to be serviced, and all of these activities occurred in low Earth orbit. From a commercial perspective, the high-value orbit is geosynchronous Earth orbit, GEO, home to hundreds of the most valuable commercial and national security satellites. These satellites are 36,000 kilometers from the surface of the Earth. If they experience any issues today, they cannot be repaired, losing valuable revenue or national security capability. GEO is a hugely impactful place to take the capability of servicing, and several companies have announced ambitions to develop those capabilities. Satellite servicing starts with what is called rendezvous and proximity operations, RPO. Two spacecraft begin thousands of kilometers from each other and use a powerful suite of sensors to perform precise navigation to converge their orbits within a centimeter of accuracy. In the most challenging cases, robotic operations will be required, nudging a solar array or aperture that failed to deploy, or even replacing a failed system on a satellite. These activities can spectacularly restore capability, but are potentially perilous to both the servicer and the client satellite. Improper actions or inadvertent error can generate orbital debris, which is a danger to all spacecraft. This potential for debris generation provides a clear connection to the Outer Space Treaty's Article 9 references to harmful contamination and harmful interference, which the U.S. government is obligated to avoid. Given Article 6's requirement for continuing supervision, I think commercial satellite servicing must have some form of scrutiny by the federal government to protect the sustainability and the safety of the space environment. However, as has been mentioned by several today, should this oversight regime be too onerous, the initiative will simply go to other countries. Having other countries set norms around RPO that may not be based on a technical or safety basis could be very damaging to both national security and to our economic interests. At the FAA's Office of Commercial Space Transportation, I learned that a simple regulatory change, even editorial, takes a minimum of 2 years. A complex rule can take 5 or more years to achieve. This is a nightmare in the face of rapidly evolving technologies and business plans. However, I also saw the use of industry consensus standards. Industry standards allow companies to be an advocate for their innovative technologies and business plans. Standards can be updated much more easily, and long-term, they could be helpful in enabling regulations that are performance-based and not prescriptive. When I was at DARPA, I helped initiate a joint program with NASA called CONFERS, the Consortium for Execution of Rendezvous and Servicing Operations. The goal of the program is to fund a consortium to bring together technical experts across industry and government to develop consensus technical standards for rendezvous and servicing. These standards could provide a basis for evaluating compliance with the Outer Space Treaty by the U.S. government and may prove a successful model for future oversight of other areas as well. A few other comments regarding that oversight. Today, most cameras in space are pointed down at the Earth, not at other satellites. Any oversight must consider the powerful suite of sensors carried by satellite servicers to accomplish RPO with respect to the protection of national security operations and proprietary commercial information. For national security, it'll be critical to verify that a commercial satellite is in fact acting cooperatively when it approaches another satellite and is operating in a predictable way to prevent misunderstandings. Verification of RPO activities will likely be the most stressing case for space traffic management. A single window to industry for authorization and verification of servicing operations seems best. Thank you, Mr. Chairman, for the opportunity to discuss this important and exciting topic.
Thank you, Colonel Milroy. And thank you to each of you for very helpful testimony. Let me start with a question that we asked the preceding panel as well to each of you, which is, should this committee take up legislation to provide greater certainty and predictability and clear incentives for the private investment of resources in space? And if so, what should the contours of that legislation, the contours of any such regulatory regime be? And to what extent does the Outer Space Treaty serve as a barrier to doing so?
Well, perhaps, Mr. Chairman, I could start. Having lived the dream and come up against a stark reality that we had a mission plan, we had investors invested, but didn't have a way forward at the end of 2015. Not that the government, there was anybody that didn't want to say yes, there was just no mechanism to do so. So we were able to, through months and months of expensive and time-consuming effort, both on our company's executive side and the great people throughout all of the interagency federal stakeholders, found a solution, but a temporary patch in this mission approval. However, the mission approval was, once it was given, it was made clear that was a one-time only thing for our one company, for our one mission. And although there would be a proactive desire to continue that type of support, there was no guarantee that it could be done again. So we need a certainty. Here we are about to execute on our first lunar mission, planning further missions. And Mr. Chairman, you mentioned those peaks of eternal light on the moon. Those are indeed the destinations that we are looking at for our second mission. And we have yet to have a certainty of process in order to gain the Article 6 authorization and supervision to go there. So I did recommend a light touch regulatory environment that promotes certainty with a minimum of regulatory burden. Inaction or nothing is not enough. And we have found a way through existing protocols with a little bit more voluntary disclosure to find a way through. So perhaps that's a data point for the models that will be helpful in the more permanent solutions that are found in the future.
And Dr. Richards, let me follow up on your answer there. My understanding is that your mission approval from the FAA states, quote, the FAA made a favorable payload determination for this particular mission. However, not all non-traditional space missions may lend themselves to favorable payload determinations under the Payload Review Authority in 51 U.S.C. 50904. Future missions may require additional authority to be provided to the FAA to ensure conformity with the Outer Space Treaty. My question is, what impact did that statement have on Moon Express and the certainty you need to continue to receive funding from investors to facilitate future missions?
And that letter was written on July 20th of 2016, which was a venerable date, of course, for that to happen. It was great news that the authority was given for that once. It was an indication that it is possible, but it was certainly not an indication of certainty for the future. We are moving forward with the belief that the United States will continue to find a way. These hearings and the conversations that are underway right now are giving us great hope that these things will happen. Our colleagues in other industries want to go to asteroids and they want to go to Mars. We want to go to other destinations too, and it's going to start happening fast and frequently. So although we're not there yet, I have confidence that these conversations and others will lead to a permanent solution that we can all live with and flourish with.
Do others have thoughts on the
Senator
initial
Cruz, if I could.
Sure.
You know, the language that you just quoted, I think, is much scarier for the people coming afterwards than it was for the one who received it. And we certainly fall into that category. And this is not science fiction. This is not academic. These satellite servicing missions are happening, both RSGS and Restore-L, in LEO and GEO, both of which are critical regimes. And it's a race that we can't afford to lose in America, whether it's for national security or economy or both. And our experience is that we are in a state of relative complete confusion. We don't know what agency will take it. We've heard some negative reactions in terms of what's occurred. We need certainty because our investors want it, insurers want it, the private sector must have it. And we don't have that situation now, which is why we implore you to take action. Now, that action should be common sense, should be balanced. Just to go back to the Connecticut analogy, we
Common
don't say,
sense. I'm sorry, this is Washington.
I know. Hope springs eternal in a science fiction fan, Senator. We don't want to see the federalization of Connecticut, as described before. But there should be a speed limit. Now, I've been to Connecticut. They don't abide by that. But nonetheless, it's helpful. And I believe that that balance would be taking the process that we went through at the FAAST and ensconcing it and formalizing it. It's working. I think both Dr. Richards and I had positive experiences with it. What we don't want to see is whole new bureaucracies stood up, new requirements, new licenses, new processes. We've got a system that's working. Let's ensconce it. Let's proceed. And relative to your question about the Outer Space Treaty, there's actually an alignment here between private sector interests and certainty and the requirements of Article 6. By going the simple route and just creating the enhanced payload review process, we can solve both at once. And part of the reason I'm so concerned about Article 6 is not because of today. I think the Department of State, the Department of Defense have done a great job, but it's because of tomorrow. No two words in the English language scare me more than continuing supervision, particularly when it comes to the government. And as we mentioned with export control, we saw the worst of what that can mean at times. When we would go to Russia, I would go with a number of government monitors breathing down our necks, monitoring every word that we would say. And we had the pleasure of paying for the privilege, by the way, $150 per monitor, per hour. We would joke with the Russians that the KGB may have spied on you back in the day, but at least they had the good courtesy to do it for free. So we need a regime that locks in this common sense approach, dare I say it, because if there's some sort of crisis, and this is what happened with export control, there was an incident. And when that occurs, then you get bad policy. You get knee-jerk reactions. So let's take this time now to create a system that benefits national security, benefits the private sector, and meets our Article 6 obligations.
So let me ask two final questions. The first is, if there should be an agency in charge of implementing these rules, what agency should that be?
Sure.
And the second question I want to address specifically to Mr. Marquez, which is that Planetary Resources is establishing a European headquarters in Luxembourg to conduct research and development activities in support of commercial asteroid prospecting. I wanted to ask, how does the competitiveness in the United States compare to Luxembourg and other jurisdictions, and what can we do to ensure that America remains the most competitive place in the world for commercial space entrepreneurs? And either or both of those questions.
Well, maybe I'll take the first half and then turn the other to Peter. Relative to the agency, please don't make me go to any more agencies. Go to enough as it is. The FAA Office of Commercial Space Transportation has demonstrated that it's capable, it's willing, and it can be successful in running an interagency process. Because ultimately, it's never going to be a single agency, that we're going to have to go to the Defense, we're going to have to go to the Department of State. What I need is a single belly button, is a single door, is an ombudsman to the rest of the federal government, so that, like Dr. Richards, we don't have to go to every single agency ourselves as a private sector entity. Via the enhanced payload review process and interagency review, the AST has proven that it can take those other agencies, bring them together, and get through the process. So I'd like a single front door for the government, and then for that agency to go to the other departments with interest and come back with a response. And I believe the most expeditious way to do that is to go through the FAAST, since they're doing it already, and I have to go there.
Any different views on that question from Mr. Golds?
I just have a few, I wouldn't say different, just more detail on it. One, I think, foundational item we need to do is in Article 6, it says authorize and continually supervise. Nobody in this room knows what that means. We need to work on what that means and what our obligations is. We interpret our obligations to be under authorize and continually supervise. Again, I agree with my colleagues here that regulation needs to be a light touch, even if it is regulation. I think something akin to even filing a flight plan is good enough. Again, I also agree that having a known front door and having that front door staffed and funded to review these types of activities, having the process and method known for which you're going to be authorized and supervised is known, that there's an assumption of compliance with the treaty. None of us want to violate the treaty. We're in this for business. We have no interest in making space an unpredictable and unsafe place to operate. The second one, or the fourth element here, is that it needs to be transparent. The process, we have to know what's going on inside that process. And the final one, and again, coming from the national security community, is as a company, I want to know if I'm denied, I want an avenue for redress and appeal, to be able to change something that may be a national security threat, so I can still do my operation, but do it in a way that is not an issue for national security. To your second question, Senator, about competitiveness versus Luxembourg, our subsidiary in Luxembourg is taking advantage of a great opportunity in that we have access to engineers from around the world that we would not be able to have access to here in the United States. Gives us an opportunity to access all those people due to things that Mr. Gold is very well aware of on export control issues. The competitiveness, I would say, is that they have taken initiative to not only create an analog to Title IV of the recognition of the right to own resources that you obtain from objects in space, but they've taken the next step to put that structure in place that meets their Article 6 obligations. So there is a certain level of certainty in operations to be conducted in Luxembourg. The Emirates is doing the same thing. I've actually heard positive language from the Chinese about trying to do the same thing. So this is a growing area where I think competitively, this is no longer just a space race. This is a legal race. It's a race to give surety and predictability to the commercial space industry. And we're not looking to completely uproot and move to another place, but we're taking advantage of the opportunities it gives us to get that wonderful staff that exists elsewhere in the world.
Mr. Chairman, I'd just like to reinforce, first of all, yes, this most definitely is a legal race with national security implications. So I'd like to pile on that statement. As far as who should be in charge of oversight, I think the most important thing is that right now, none of the agencies proposed have the resources to appropriately oversee some of these activities. They don't have all the technical experts that are needed in these areas. They may have some. But I think I would like to say that AST has a very high concentration of space experts with a variety of backgrounds and expertise in this area. And it makes sense if you're going to give responsibility and you have to find extra resources to start with where that dense population already exists.
Thank you. So let's go to what briefly each of you might think are standards that you think should be put in place domestically that then could be used as precedents for international standards that our competitors around the world would then understand that they would have to meet because we were the leaders. So let's just talk about, if each of you could just give us a couple of standards that you'd like to see, if we did legislate, put on the books.
Sure. Well, I guess if we go in sequence.
Okay, sure.
I mentioned maximum certainty with minimal regulatory burden. So I mentioned a presumed or a deemed approval, and I think that's an important concept. When we go to whatever agency is selected to adjudicate this, we're not going as a commercial company asking permission. There should be a presumed right of commerce in space, just like there's a presumed right of commerce in aviation. But that doesn't mean you don't have to file a flight plan. So being transparent about what each of us wants to do in space is important to make sure we're not interfering with each other or somebody else. As Peter has said, we don't.
So that should be a standard?
That should be a standard.
Another standard?
Right. So none threatening to any national security interests, number one.
Okay, number one.
Two is not abrogating or threatening any of our international obligations under treaty. Number three is not interfering with ourselves or any other foreign activity in space.
Okay, thank you. Mr. Marquez, international standards that we should set here domestically that you think would be important to have internationally?
Again, I'll concur with my colleague from Moon Express. I think the irreducible standard here is one of harmful, of non-interference, of non-harmful interference, and making sure that whatever we approve to do here in the United States is not going to interfere with our own actions, the actions of our government, and the actions of our friends and allies who are also signatories to the Outer Space Treaty, and even those that are not signatories to the Outer Space Treaty. There are probably a few other technical things that would go into a specific review.
Well, just give us a couple.
Well, I mean, I think the ability to show that you can maintain positive command and control over your satellite, and the ability to communicate with it so that it won't go awry and go off stray, those types of things. And then, again, like I said, filing a flight plan so that people know where you're going and the purpose of your mission. The transparency in what it is that you hope to achieve in your activity.
Good. Mr. Gold.
So I think you'll hear a lot of repetition, but national security interests, international treaty obligations, non-interference, domestic or foreign. And I think another aspect that we need to pay attention to is that if there is a negative response to an application, that the answer isn't no, but yes, but, in terms of an agency explaining to a company what it is that they need to do to try and get to yes. Because no really doesn't leave a lot of room for innovation or growth, and I think that's something that we've seen be a problem in the remote sensing area in the past. So I think if you just take those simple values and put it into a light touch, almost a registration-based regime, that it would function. And per the race discussion, this is a race.
And that's all you would really expect from United Arab Emirates or from India. Is that what you're saying? The same kind of standard?
Yeah, I think UAE in particular has done an excellent job of establishing a common sense approach that balances the need for a secure environment and for non-interference, again, foreign and domestic, without being too heavy touch. And that's basically what they've done. Unfortunately, a lot of this doesn't lend itself to blanket solutions. A lot is a case-by-case basis, and you have to have a policy that is sufficiently broad and flexible to handle that. And I think if the U.S. leads and joins, other countries like UAE, et cetera, we can see this develop as an international standard. The last thing I would say is that, relative to the ITAR parallel, there can be crises or incidents that lead to bad policy. And we are going through a small sat revolution where there could be hundreds, thousands of small sats out there. We just heard about the deployment with India of 100 or more in one launch. That's a reason that we need to get these rules in place in a manner that balances innovation, because we want that to occur with the security of the environment in space.
Colonel Melroy, let's deal with that question. India is launching, and they're doing things that we've never done. So what standards do you want to have set here that then we would say, well, these are what we believe are legitimate standards, India or other Middle Eastern countries? What are you doing to meet these minimal standards that we think should be in place? How can we, what are those standards from your perspective? And how would we then, if we establish them, ensure that Middle Eastern countries, India, then met them so that there was a certain rule of the road for outer space going forward?
Thank you, sir. I think that's a wonderful question. I have to say that we've heard some less than flattering things about lawyers here, but in my opinion, we need to get the engineers and the lawyers together because these need to be technically based. The truth is that everybody has preferences for how they want other people to operate their satellites to the benefit of their own country. But if you don't have a basis, a safety or technical basis that is actually going to generate mistrust. You know, why do you want me to do it that way? So it's very, very important that I think that we should use the universal language of physics. Space is a unique domain. It's not intuitive the way it is to us here in the ground and the maritime and even the air domain. And so really understanding the implications of what you're doing. A great example of that is you might think it would be a standard to stay a certain distance away from any given satellite. However, that's meaningless in low Earth orbit as satellites might be passing each other in orbits that will never collide, ever. On the other hand, they seem to be coming close to each other. So you really have to understand actually what's going on. A better idea is that you have a passively safe orbit so that you won't collide with any other satellite until if you decide to do a rendezvous at the very latest practical moment, which is usually guided by the physics of the client satellite. So those are the kinds of predictable behaviors that I think give us confidence that people actually have done the science behind what they're doing, and they're not going to collide with each other and generate debris.
What is your training as Colonel?
I'm an Air Force test pilot, sir.
What was your major in college?
Physics.
I was wondering about physics. No, so you want us to abide by the rule of physics, huh? The rule of law and the rule of physics. Huh?
Exactly. I think they can be worked to be harmonized.
Right. And lawyers and physicists can learn from each other a little bit about how then to put that into a usable form.
Yes, Senator. Perfectly said.
Thank you. Thank you so much for your service to our country. Thank you, Mr. Chairman.
Thank you, Senator Markey, and I would note for any skeptics in the hearing room that for those who don't believe in miracles, we've seen not one but two witnesses on this panel defend lawyers. I suspect we may go many years in the Senate with that ever occurring again. So with that, I want to thank each of the witnesses for participating in today's hearing, both in the second panel and the first panel. I think it was a very educational and enlightening hearing. It is the intention of this committee to go forward with legislation seeking to create a system that incentivizes the investment and maximizes the potential for exploration in space. So I would extend an invitation to each of our witnesses and to other interested players in this arena. We are in the process of a multi-part series of hearings to learn, to study, and hopefully to come to consensus about how to create the best system of rules to provide certainty and maximize investment. The hearing record for this hearing will remain open for 2 weeks. During that time, senators are asked to submit any questions for the record, and upon receipt, the witnesses are requested to submit their written answers to the committee as soon as possible. And with that, the hearing is now adjourned.